Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Today we'll be taking up first Black Voters Matter Capacity Building Institute versus Secretary, Florida Department of State, case number 2023-1671. Justice Kennedy is recused, and we're going to make sure that we have enough time to cover all this today. There's a lot. It's obviously a very important case, and there's lots of moving parts and issues and stuff, and so we won't let it get out of hand on time, but you know, don't rush through, because if we need more time, we will, and we'll make sure that it's equal.
Good morning, and may it please the court. My name is Christina Ford, and I represent the Black Voters Matter petitioners, many of whom are with us here today. Your Honors, over 2 years ago, the legislature passed a redistricting plan that it knew did not comply with the state constitution under this court's precedent on the non-diminishment provision. Below, the trial court faithfully applied that precedent, and unsurprisingly, it found a violation of the Florida Constitution. Although the first DCA reversed, it did so only by excusing itself from this court's precedent in an opinion that none of the state respondents attempt to defend before this court. This court should resolve this case by adhering to its existing precedent on the diminishment standard, under which petitioners have unquestionably shown a violation of the Florida Constitution. And this is not particularly a close call. Both the House and the Senate have conceded that petitioners proved a diminishment violation, and they are not asking this court to change that standard. Nor does this court have any reason to do so. As this court has already recognized, the diminishment provision, both the diminishment provision itself and the standard adopted by this court, does not permit, nor does it require racial gerrymandering. And whether the enacted plan complies with the Florida Constitution should be the sole question before this court today.
Well, obviously we have to consider whether it complies with the United States Constitution as well, right?
Your Honor, I don't think that you need to reach that question today because the trial court did not impose any particular remedy before the legislature. It passed the baton back to the legislature to draw a remedial district. And so because we do not have an actual remedial district before us today to judge the Equal Protection Clause arguments that the state respondents are making, I think under legions of racial gerrymandering doctrine, you don't have the ability to actually apply it to a hypothetical district.
So I understand the argument to be different. I think the argument on the equal protection is as to the burden of proof, not to the remedy. And so you've mentioned that the remedy would be sending back to the legislature, but isn't that a distinct argument from what the legislature is making, that in order to satisfy your burden of proof, you need to show that this hypothetical other district is possible without violating the Equal Protection Clause?
Yes, Your Honor, I agree those are different questions, and if the court agrees that it was our burden of proof to put forward a lawful remedial district, then I agree the court would have to engage in those questions. We don't think that is necessary today. Under this court's precedent, an analysis of the diminishment provision just involves two maps, the enacted map and the benchmark map, and doing a comparison and concluding whether there's a violation. And under the existing precedent, there unquestionably is. And so we think it would be premature for the court to reach the equal protection arguments that the legislature is raising, especially when the legislature said before the public that the districts that it passed were constitutional. And so
I know that the parties, it seems like on both sides you kind of agreed to follow this kind of unorthodox approach of stipulating to what you stipulated to and having the court make the decision without a trial. I mean, you guys I know do this stuff all the time. It seems like usually there's, lots of alternative maps and experts, and you get the drawers in, and why did you do this and that and whatever. It seems like from reading the proceedings in front of the trial court, there was just sort of a general understanding that because of the way this had played out in the legislature, that people were sort of aware of the universe of options, that we have the benchmark, then we have the 2 alternative plans that got vetoed, and you have the Duval-only thing and the East-West thing. And so I'm wondering from our perspective, even if in a different scenario where you hadn't had all that background in the stipulations and everything, you could imagine maybe sort of just deciding diminishment and kicking the can down the road on equal protection. It seems like in this case, that really doesn't seem like it would be a reasonable thing to do, because it doesn't seem like the alternatives at the next step would be any different from what already has been put on the table. Is that wrong?
It's not necessarily wrong, Your Honor. I agree that if this went back to the legislature, I think it is most likely that what they would choose would be the district from Plan 8015 or the district from Plan 8019. We don't know which one it would be. And if the court does want to reach that question, we think that those 2 districts are proof positive that the legislature can draw a district that complies with a non-diminishment provision and takes traditional redistricting criteria into account, as they said they did when they drew those districts.
You seem to give a lot of weight, or at least you did in your answer to me, to the state's statement that the district was constitutional. I'm wondering, leaving that sort of stipulated component of the record aside, if we found that a district had to violate equal protection in order to meet the non-diminishment test of the Florida Constitution, I think from a supremacy clause standpoint, you'd probably concede that we would have to adhere to the equal protection obligation first, wouldn't we?
So, Your Honor, I think it would be very difficult to conclude in the abstract that a district would have to race would have to predominate in the drawing of a remedial district, and that is because there's a difference between racial consciousness in redistricting and racial predominance. And it is black letter law that just...
How would you explain the difference between those 2 things?
Sure. So the Supreme Court has drawn some lines here. And one line that they've drawn is intentionally drawing a majority-minority district or intentionally attempting to comply with a minority voting provision like the FDA's does not show racial predominance.
Can it ever?
I don't think so. Not under Bush v. Vera, not under Allen. The legislature would need to go further. So in Miller, for example, the Supreme Court said that a party claiming racial gerrymandering has occurred needs to show utter disregard of traditional redistricting criteria, and that is not what we see in these plans.
Part of what's hard about this whole area of the law is obviously there are so many different, you used the word legion earlier, and I think that's right. There are so many judicially created doctrines and so many sort of artifices of phrase that have been invested with specific meanings, and the meanings may or may not have anything to do with the actual text of the Constitution. I guess what I'm getting at is, as a matter of first principles, if we're going to sort of go down to the studs, can we agree as a matter of first principle that both under the Florida Constitution and under the U.S. Constitution, it is ultimately an individual's right to vote that is at issue, not a group's right to vote, but an individual person's right to vote?
Yes and no, Your Honor. I think most of the doctrine recognizes an individual right to vote. But I think that the VRA and the Florida Constitution do speak in terms of a minority group's ability to elect their candidate of choice.
Do you really? Yeah, I see that too. But does that? It says what the minority group has is the ability to elect a candidate of its choice. You won't concede that at the end of the day, only individuals have a right to vote? I mean, it seems to me like that's a very fundamental first principle that helps cut through a lot of the thicket, doctrinarily speaking. If we just sort of keep as a touchstone the fact that what we're really looking for was any individual's right to vote abridged or burdened on account of race, it seems to me that that's a sort of clarifying first principle if you agree to it. If you don't agree to it, then we have a real, I think, a real divide, because I don't think our cases and certainly not the U.S. Supreme Court's cases, stand for the proposition that any group has a right to vote. When I go into a polling place, I go in by myself. So you're not ready to concede that, or you do?
I don't concede it, Your Honor, because I think redistricting is different. In a lot of the cases where we're looking at other, voter ID provisions or something like that, of course it's about individual rights. But redistricting is, by definition, a collective group of voters, and how you decide to arrange.
I think your
those
argument
groups
works at the federal level when you have this very intentional structure in Section 5 when it comes to diminishment. But here we're in state court. We're talking about a state constitution. That historical context doesn't exist for the adoption of this constitutional provision. So redistricting law aside, which is a federal issue, in the context of the FDA, would you be willing to concede that this refers to an individual right versus a group's right?
I think it still refers to a group right, Your Honor, and
does that not create an issue with the 14th Amendment, though?
No, I don't think so, Your Honor. This court said in Apportionment 1 that it would follow prevailing United States Supreme Court precedent when it was interpreting these provisions, because they were borrowed.
So help me with that, because as you know, the Secretary makes a pretty robust argument that we should recede from portions of the precedent. I understand your reliance argument, and I understand your controlling precedent argument. So just going to the, if we decide to recede, what should we recede to? I can appreciate the old soil, right? This is obviously a term that's been transplanted from another source. But how did we then jump from this old soil concept to now we're going to incorporate DOJ guidelines that post-date the adoption of either the VRA, Thornburg, or the Fair Districts Amendment?
Yes, Your Honor, I don't think this is just about bringing over the old soil, because I think the Secretary's argument is wrong. So the argument that he makes that the 2006 amendment to the VRA fundamentally changed the standard, it is based on a fractured Senate report that no court has ever adopted. And in fact, courts that have encountered it have rejected it.
And I'm not really concerned with the Senate report. I don't think that's dispositive of the interpretation by any means. But here we have state constitutional provisions, 2 subsections. We have an explicit reference in the Constitution that neither of these are supposed to dominate unless there's a conflict. How do we go from the plain language of that text that was presented to the voters of Florida and say, okay, now we're going to go to DOJ guidelines on last legally enforceable plan and functional analysis and all that? How does that get incorporated into the state constitution through just this phrase and the non-diminishment clause?
Sure, Your Honor. Well, the Section 2 and Section 5 were well-known provisions at the time, and the sponsors of the amendment and the public talked about that we were going to track these requirements. Of all of Congress's laws, I think the Voting Rights Act is one of the most popular and well-known among the public. So I don't think it would be a surprise to Florida voters that they were incorporating those standards when they adopted that language.
Can we get back to predominance? So I'm wondering about the extent to which the Fair Districts Amendment itself sort of changes kind of the backdrop against which you would read predominance. So you have this sort of gerrymandering predominance cases, and then you have the attempt to comply with Section 2 predominance cases. And it seems like in the Section 2 context, the court most recently, I guess the 4 justices, said that if you're just trying to comply with Section 2, that it's okay to be conscious of race, and you can't subordinate the traditional principles and whatever, but you're not putting yourself into the sort of danger zone of predominance just by having a racial target, or at least seeing if the racial target can be met, and then balancing that with the other things. It seems though in the gerrymandering cases where you start off, where you say, look, no matter what else we do, we have to make sure that we achieve a certain racial goal, which it seems like the FDA kind of bakes that priority in by saying that Tier 1 trumps Tier 2. Doesn't that kind of stack the deck to where the legislature, if they're going to comply with the FDA, and where the whole process, the way everybody talks about this, we do the minority districts first and then we build around that, doesn't that kind of immediately put you in the zone where you're having to worry about strict scrutiny and deliberate racial sorting and all that? in a way that you might be able to kind of argue around it if the legislature could say in good faith, look, this is all just a mix of things that we look at and we're trying to balance everything together. It seems like the FDA itself sort of takes that option off the table.
Your Honor, I don't think it does, and that's because the diminishment test and the functional analysis behind it is very sophisticated, and it guards against racial gerrymandering and prioritizing race above all else. And here's how it does that. There's a couple ways. I mean, this court has already said in Apportionment 1 that the non-diminishment provision does not allow the legislature to use a racial target or a racial quota.
Can I just, but it seems like in that sense they're just talking about kind of having sort of a pre-existing assumption as to what number you have to hit for diminishment purposes. And I think they're saying that in the context of you're looking for just a very granular kind of specific analysis of diminishment, that you can't just sort of go in kind of ex ante and say we're going to keep it at 65% or whatever. That seems like a different thing than saying where the FDA just facially says whatever it takes to avoid diminishment, and that may be, in, you know, depending on the facts, it may be X percent or whatever other percent, that has to take priority over tier 2, over the compactness, which, and also the other thing with the FDA is that it seems like, you know, in a normal redistricting case where you don't have these constitutional standards, the legislature's range of traditional criteria is much broader, you know, preserving cores of existing districts, protecting incumbents, political gerrymandering is okay, et cetera. So it seems like FDA kind of had this maybe unintended effect of constricting the allowable traditional redistricting criteria on the one hand, and then on the other hand requiring that race be prioritized, which it seems like we're just sort of setting up sort of a head-on conflict, or at least the possibility of a conflict with the Equal Protection Clause just on its face.
Yeah, Your Honor. I do want to reserve time for rebuttal,
Yeah,
but
go
I want
ahead.
to answer this question for sure. So I think when you suggest that the Fair District Amendments might require the legislators to prioritize race and avoid diminishment at all costs, I don't agree that's how the diminishment provision works. And so let me give you an example. At the start of this redistricting cycle, there were 4 black districts that were considered to be ability to elect districts for black voters. We now only have 2. One of them is CD5, which is at issue today. The other is CD10. And the legislature concluded that that district no longer had to be protected because the minority group, the black population there, had sort of shrunk in voter turnout and voter performance over the decade, and it was no longer electing a candidate of choice.
So there's nothing to diminish. I mean, all that shows is that the benchmark is gone, right?
I'm just trying to make sure this court understands that this doesn't lock in.
No, we understand that. I mean, but the point is, you do the functional analysis, you look at the benchmark plan, you do the functional analyses, you see what quote unquote performs, right? In that case, District 10, I guess they decided it no longer performs, so there's nothing to protect. But then the FDA kind of requires you, again, not with assuming certain numbers, but it does require that the substantive result before and after be the same, right, in terms of ability to perform. And then you, on the face of the FDA, and I'm not saying that anyone has any bad motives or anything, I think one of the things that's very difficult about this case is that the FDA probably doesn't pass if people don't have confidence that the minority protections are going to not be swallowed up by the non-political stuff and whatever. And so it just seems though like you're kind of baked into this idea that race has to be the priority, which isn't the end of the conversation because you still have all the strict scrutiny and everything. But it does seem like that's kind of the position that the FDA on its face puts the state in.
I think that in practice, the legislature has shown that it can harmonize these standards. And part of the reason we know that is because the legislature passed 30 legislative districts and 6 other congressional districts under the non-diminishment provision. And the legislature contends that that is working well. They're not asking the court to change the standard, unlike the secretary. And so in practice, I think the legislature has shown it can harmonize these principles together.
I think they would say, though, that the way, and I'm curious, we'll hear what they say, but I think they say that the way you harmonize it is by essentially not availing itself of the sort of prioritization that's in the FDA. Essentially, that if you can do compactness and preserve the performance of the districts and meet the other tier 2 criteria, then you're fine. And in that sense, it's okay, which in a weird way sort of flips the FDA on its head, because it kind of tells the legislature, comply with tier 2, and then if you can, keep the minority districts. Do you have a thought on that?
Your Honor, I mean, I think it is true that there's a tier 1 and there's a tier 2. The legislature is obligated to comply with all of them. And just because, you know, in apportionment 1, this court said that compactness might yield some to comply with tier 1, I don't think yield some suggests racial predominance at all. When we have racial predominance, we have, you know, utter disregard of traditional redistricting criteria, and compactness is one
Utter
of them.
disregard or impossibility. Do you concede that under some configurations of a demographic spread, it might just not be possible to not have racial concerns predominate? And if you do concede that, why is that not the case with respect to East-West CD5?
I do concede that, Your Honor, that there might be some instances where it is not possible to reconcile these. I do not think that is what we have here.
Can you
Well,
tell me
I mean,
why?
but that's their argument, right?
Yeah.
I mean, it goes back to the first question on burden of proof. It's that's the legislature's exact argument. We're in a position where we're not approving a map or not a map. We're evaluating whether or not the legislature's chosen action conflicts with the Constitution, and they're saying it's impossible to do something different without violating. You have attempted, and you know your client attempting to meet their burden of proof is provide an alternative that the legislature says race predominates. I mean, that's exactly this case, right?
Yeah, so the state certainly uses a lot of rhetoric to describe the East-West CD5, but the plan in 8015 performs very, very well on traditional redistricting criteria, which is what the trial court found. I recognize that the district is long, but on a lot of factors, it does very, very well. So for example, on adherence to political and geographic boundaries, that means adhering to a county line, a city line, a waterway, or a railway. 98% of its boundaries follow one of those existing boundaries. That is better than all but one district in the enacted plan.
How is that possible? It cuts across like 4 counties. It narrows to 3 miles at one point. What 98%? Which boundaries are we including in that computation?
A county line, a city line, a major roadway, so like a U.S. highway or a state road, railway, and waterway. And so the district, if you follow it in our reply brief, I think we have a picture of it on page 24, where we show exactly how it follows those lines. So I realize, you know, they called the Duval part, like I think they called it a seahorse head. If you actually look at those lines, it is following the Duval Nassau County line to a T. It's curvy at the top because the Nassau River is curvy. And then it takes US 17, goes down, takes the beltway around, I-295, it joins back up to US 17, and then it takes the Duval-Clay County line and runs it straight back. Jacksonville has to be split because it's too big for one congressional district, and it is a reasonable way to split the city of Jacksonville. And it shows that the legislature was really, really taking existing boundaries into account, which is one of the core tier 2 principles that it had to take into account.
Unless we get into the whole strict scrutiny thing, though, for you to prevail, we would have to say that as a matter of law that the East-West configuration is compact, right? Because compactness is a shall. I understand that, let's say we concede that it's good enough on the political and geographical stuff, but it still also has to be compact. If we're going to say that race didn't predominate over, that race didn't trump compactness, just to get away from the loaded word of predominance.
So, Your Honor, I think that would be inverting the racial gerrymandering standard. So to prove that racial gerrymandering occurred, you have to show that race predominated, right? That it dominated, it controlled over all else. There's not a but-for test that we have to affirmatively prove, that it did amazingly well, that it scored super high in all of these other criteria. And the legislature is trying to sort of flip the burden back on us for us to prove that maybe there was some other but-for motive that could explain this district. But that's not the standard under racial gerrymandering doctrine. So I think that would be an inappropriate burden to hold petitioners to. And again, I just want to emphasize that here all we're saying is there are, we think for the state to prevail here, they would have to show there's no possible way to draw this district without race predominating. And I would encourage the court to also keep in mind Plan 8019, the Duval-only district, which the legislature itself said this district faithfully adheres to all Tier 2 principles.
Right. And then the problem with that one is the surrounding district. The donut, the dough part of the donut as opposed to
Yeah,
the
Your Honor,
whole.
respectfully, I do not think that district is particularly weird at all. You have to split Jacksonville somehow because that's too many people for one congressional district.
Can you, before you sit down, can you address the whole strict scrutiny thing? Because it's possible that we would have to get to that.
Yeah. And Your Honor, obviously I do not think that the court needs to get to it, right, for the reasons that I've already said. But if it does reach that issue, it should hold that compliance with the non-diminishment provision is a compelling state interest.
Okay, and that seems super weak. I mean, how could that possibly be the case?
Your
In
Honor,
the sense that there's no, for there to be a compelling interest, there has to be sort of a pre-enactment record of, some sort of, problem that the law enactor is trying to address and that it's narrowly tailored and all that. It just doesn't seem, and this isn't a criticism of the proponents of the FDA or anything, but it just doesn't seem like the citizen initiative process lends itself to that sort of a thing, to that sort of mental process that has to be gone through.
Yeah, Your Honor, I agree. A ballot initiative is certainly very different than an actual regular legislative enactment. But as the trial court said, if that is the standard, then the state could never pass remedial measures.
Well, the state could. I mean, through a rational process. I mean, the legislature could decide, look, there's discrimination, just like when Congress passed the Voting Rights Act. There's discrimination that needs to be remedied, and et cetera, et cetera. But it just doesn't seem like, if the people of Florida decided, hey, we want, proportional representation in our state universities and whatever, and put that into the Constitution, like you wouldn't be saying that that's okay under federal law, right?
No, not necessarily, Your Honor. Even though there might not have been a record of enactment like there was for the VRA, I think there was certainly a history of discrimination in this state that the voters were responding to. So we have in our briefs recognitions from both the federal and the state judiciary about what they call the substantial inability of minorities to elect candidates of their choice to higher office, and particularly to Congress. The trial court lays out that there was over 100 years between Reconstruction when Florida elected its first black representative to Congress. And the Florida voters enacted the Fair District Amendments with that history in mind. And I think it is telling that the first time that the state decided that these provisions were not necessary, they eliminated a district that had elected a black candidate of choice for 30 years. We think there is an adequate record of discrimination in this case. If that ends up being the hinge point that this court comes down to, we would request a remand to develop that evidence rather than have this court, take drastic action and say there's nothing that could have supported this amendment. I'd like to reserve some time for rebuttal. Thank you.
We can start off with 5 on rebuttal and then add if we need to.
Mr. Chief Justice, and may it please the court. Plaintiffs in this case are seeking to dismantle the race-neutral map that the state drew in North Florida and to replace it with a racial gerrymander. Nothing in the Florida Constitution requires that result, and the federal Constitution would forbid it. We've been talking a lot this morning about the federal constitutional argument, and I wanted to spend some time talking about our argument that the non-diminishment provision has not been violated in the first place here. Excuse me. The non-diminishment standard depends on establishing a valid benchmark from which you can measure diminishment. In our view, the non-diminishment standard incorporates precondition 1 of the Jingles test, which says that in order to establish a valid benchmark, you need to establish that the minority population in that district is reasonably compact. And that is actually more or less what the first district held below.
But why would you, it seems like, a couple of the justices have expressed some concern about sort of baking all of the Voting Rights Act stuff into the Fair Districts Amendment, it seems like you're sort of not only baking Voting Rights Act stuff into it, but you're baking Section 2 Voting Rights Act law into Section 5, where it just seems like this is complicated enough without making the benchmark thing super complicated. I mean, this is very mechanical. You look at the existing plan, you look at how it performs, and then you kind of see what you have to do from there. Like, why, it just doesn't seem like that would be a sensible way for us to resolve this.
Well, I mean, I disagree with that, Mr. Chief Justice. I mean, I guess I would say is that we take as a given this court's determination in Apportionment 1 that at least as a starting point, you do use Federal Voting Rights Act principles. I mean, the language in the FDA was kind of lifted whole hog from the Federal Voting Rights Act, and we don't have a quarrel with that. It's just the starting point, to be sure. Mm-hmm. I mean, we certainly offer some Florida-specific reasons about the history of the Fair District Amendment itself that I think supports that. But I think the overarching reason, Mr. Chief Justice, why I think that would be reasonable, keep in mind, I think we should strive to read the Fair Districts Amendment's non-diminishment standard not to require the state to lock in racial gerrymanders for all time, at least if the relevant demographic data.
It's not necessarily, I mean, it depends on how you define gerrymander. I mean, if you mean an irregularly shaped district, it doesn't seem like it locks that in necessarily. I mean, if you're talking about preserving performing districts, if that's the definition of a gerrymander, then maybe it does.
Well, on the contrary, Mr. Chief Justice, if it is in fact the case that there isn't a requirement in the diminishment standard that the minority population be reasonably compact, I think that is more or less what would be required. You would be required to protect, in the name of non-diminishment.
I feel like, did we cut you off? Is there anything other than compactness that is relevant to defining a pre-existing community for the purposes of districting or redistricting as part of the baseline sort of analysis? Is it that there has to be some sort of historical explanation, some rootedness, factors completely unrelated to race, agricultural versus urban? Are there other considerations that are part of the step 1 determination that are relevant, or is it just compactness?
No, it's more than compactness, Your Honor. The way that we put it, and this is the way the U.S. Supreme Court has put it in the Section 2 context, is that the district the black population has to be in an area where that you could have a reasonably configured district in accordance with traditional redistricting principles. After all, the definition of a racial gerrymander is, or at least one clear way you can have a racial gerrymander, and the Supreme Court held this in Shaw versus Reno, and in the Miller case, the textbook example is where the state sacrifices traditional redistricting principles to meet a rigid racial target. And that's exactly what the non-diminishment standard would require.
So in other words, the factor that, as we've referred to in the past, Tier 2 requirements.
That would certainly be the frontline traditional redistricting criteria. If those Tier 2 requirements are satisfied, there could be others as well. And there is evidence that is specific to Florida about why it makes sense to read that requirement into the diminishment standard. If you look at the ballot summary mentioned, kind of equated the vote dilution, what was necessary to show an ability to elect in a vote dilution, under the vote dilution
and
language.
The ballot summary, ballot summaries don't always accurately reflect the text. So if we go to the text and we accept your argument that given the old soil and the way that this term originally appears in Jingles, I don't know if it's original, but it appears in Jingles, it incorporates compactness. How functionally, I think the petitioners make the point that functionally then it's no different from dilution. You have essentially a restatement of dilution in the context of diminishment. So can you explain how, if we accept that a benchmark, there would be some form of race-neutral benchmark in the state constitution for diminishment, that would be a separate concept from dilution?
It doesn't at all just restate dilution. We agree that the standards are distinct. I mean, just for a number of reasons. For example, you can have dilution by packing too many minorities in a district, by having too much minority voting strength in a district. Conversely, in many instances, it will be a lot easier to establish diminishment than dilution, because to make out a vote dilution claim, you have to not only have a valid jingles benchmark, but you also need to satisfy the totality of the circumstances. So we certainly agree that the elements are distinct, but they are common in an important respect. And that is, in both a dilution case and a diminishment case, you're asking whether the minority population has a certain level of voting strength in the benchmark district. In a dilution case, it's a hypothetical benchmark, to be sure. And in a diminishment case, it's an actual benchmark. But it's reasonable to think that in using the phrase ability to elect, which is lifted straight from the jingles case, that old soil was brought into not only the dilution provision of the Fair Districts Amendment, but also the diminishment.
Yeah, but the issue is, what minority population are you talking about? You know, in the jingles Section 2 context, you're looking at a map without any lines on it and seeing where people are. In the diminishment thing, you're looking at an actual district that maybe they shouldn't have connected these two minority populations, but that is a minority population that's in the district. But let me ask you, why, if Tier 1 bakes in a compactness requirement, why would Tier 2 then, why would the text say that you cannot be compact if necessary to comply with Tier 1? Is it that you care about the shape of the overall district, but not the minority, but the minority population itself has to be compact?
Well, in Tier 2, compactness and all the other criteria that are listed in Tier 2 are sort of non-negotiable criteria. And by the way, I take it that it's common ground among the parties that compactness is at least an element of a dilution claim in the Tier 1 standard as it relates to vote dilution. So everyone agrees that by hook or by crook, we have compactness in there. And the question is, does it also carry over to diminishment? And I guess I would say we have no quarrel with the idea that you certainly do look to a benchmark district. But the question is, is there some further requirement about where the minority population needs to be in the benchmark district? And that's where I think, I do think that constitutional avoidance comes in, because, otherwise you would have to read the non-diminishment standard to preserve this sprawling.
But the avoidance thing, and I mean, that's an attractive notion, obviously, because we would love to not have there be a potential conflict with the Florida and the federal constitutions, but it seems like the only way you really get to avoidance is if you just say that the Fair Districts Amendment requires that you comply with Section 2. Because as long as you still have an independent state requirement that you not diminish minority voters, whatever that may mean, and it's not an intent test, it's an effects test, it seems like you're just replacing one state law test for a different state law test that would be subject to all the same equal protection type concerns.
If I understand Your Honor's question, and forgive me if this is not responsive, I think it is. I think that at a minimum, our interpretation of the diminishment test to incorporate some requirement that the minority population be in a reasonably compact area does at the very least avoid the most serious and acute constitutional concerns that the diminishment provision raises. And that is when the diminishment standard requires sacrificing those Tier 2 standards at the expense of this race-based target. And I do think that all of these, the benchmark CD5 that we are talking about absolutely is a racial gerrymander, because there's no dispute that race was the reason that district was drawn. And I regret to say that was evident from this court's opinion in Apportionment 7. There is little dispute, there can be little dispute that it is woefully non-compact. It snakes in this sprawling 200-mile area to surgically capture the black populations in Gadsden and Leon County and link them with Duval County. It narrows, as Justice Correal said, to a 3-mile space in one place.
Was there any district that was less compact?
No. It was definitely by far, as I recall, the least compact district. And I'd encourage you all to look at the map as it relates in Tallahassee about, and council referred to respecting geographic boundaries like roads. Well, actually what that map did was use roads to carve up the city of Tallahassee by race, and putting in the district, FAMU and Frenchtown and South Tallahassee, and keeping out of it, the capital city.
The issue though is I'm sorry, go ahead.
I was just going to ask if you can address the preservation argument. There's that exchange in the transcript. In the briefs, there's that transcript portion, the exchange about you didn't challenge CD5, and the judge asked, are you challenging whether it was legally enforceable benchmark? And there's the, can you just address preservation?
Sure. I mean, I think in the passage that they quote in their reply, I think trial counsel was answering the court's question about whether we were challenging what this court did in Apportionment 7. And he answered correctly that we're not challenging anything the court did in Apportionment 7. And in the next page of the transcript, he says that the question is whether that benchmark is a benchmark worth preserving. And I think this is an important point about Apportionment 7. In Apportionment 7, and they rely extensively on that decision to say that this district is compact, what this court was faced with was the question whether the legislature's north-south sprawling configuration was a better remedy for a partisan gerrymander than the sprawling east-west district. There was no issue before the court about whether either of those of racial gerrymandering, which would have, of course, infected, probably equally the legislature's proposed remedy. That's just not what the parties were fighting about. I mean, we raised the Jingles argument is squarely before the court. We raised it in the trial court. We preserved it expressly, point blank, in the stipulation. We raised it in the first district, and we're raising it again in this court. And the court needs to decide that question on the merits. The court could also decide the case on the constitutional grounds. The court has asked a lot of questions about that. I don't want to steal Mr. Norby's thunder. He's making the constitutional argument in a little bit more of a he's making the constitutional argument. We are too. I would note that we have kind of a separate as-applied constitutional argument from what the legislature is advancing, which I'd be happy to discuss. I mean, we think that another reason why CD5 is not a valid benchmark is precisely because it was a racial gerrymander itself. And, we don't think that the court, that a legally enforceable benchmark can include one that this court concludes is in fact a racial gerrymander. And that would be an independent reason why the non-diminishment standard has not been violated, because
it seems, I understand, I don't fault you for making that argument, obviously, but it just seems like if I'm a court or a legislature or someone who's proposing maps or whatever, this is such an impossible area to navigate all this. If you're going to sort of have to relitigate before you even start redistricting, sort of, it's something, a gerrymander or this or that or whatever, and it just doesn't, I don't know why we would set up a test that would require looking back at sort of the origins of these things, as opposed to just focusing on, okay, this is what we have now, and can we maintain the performance without violating the Equal Protection Clause?
Yeah, I understand the concern. It's really not that much of a concern as applied in this case, because I think the conclusion that benchmark CD5 was in fact an unlawful gerrymander kind of almost leaps off the page.
Yeah, no, that's true. But we have to. But whatever we do has to. Whatever we say in this case is going to be, the legislature is going to be stuck with having to deal with that, and everybody who cares about redistricting going forward. And it seems like we should try to keep this as clean as possible. Not to mention that it seems like we're sort of bouncing back and forth with how much is the VRA a baseline or not, because it does seem like in the VRA world with Section 5, you just take the last plan as you find it. If it's been declared unconstitutional by a court, you're in a different world. But so it seems like you're kind of wanting to pick and choose sort of when we follow VRA stuff and when we don't, and
I don't
it's
think
just
so.
not persuasive.
And certainly there's no requirement of a pre-existing determination of unconstitutionality. The U.S. Supreme Court held that in the Riley case. I know that the Department of Justice sort of seemed to have a different view, even though they lost the Riley case, and that's fine. I understand the concern. But I do think the court could at least say that in this kind of a case where, you know, it's not as if it we have to, you know, have trial testimony and the like for what happened like back in the day. It just kind of leaps off the page, and the court could leave for another day whether if it were more of a complicated inquiry, whether the same rule would apply. And I guess I would say too is that, I mean, certainly the further back you'd have to go, the more difficult it would be, obviously, to conclude that any particular benchmark was an unconstitutional gerrymander. But we don't think that the court should be required as a matter of law to give effect to a district that was the result of invidious racial discrimination. I'm happy to answer any further questions the court might have, but I think it's happy to turn it over to Mr. Nordby at this point.
Thank you.
May it please the court, Daniel Nordby and Andy Bartos for the Florida Legislature. In light of the questioning so far, I'd like to focus my time on the two principal issues addressed in the legislature's separate brief. The plaintiff's burden under this court's precedents to establish a valid remedial district as a part of its prima facie case, and their failure to satisfy that burden here as to either configuration proffered to the trial court. And I think there are two key virtues to our approach. Our approach does not require this court to reconsider its existing precedent on the non-diminishment provision, and our approach does not require this court to rule on the validity of benchmark CD5. Even presuming all of that, the enacted plan should be upheld on this record. First, on the question of the burden of proof, a consistent through line in this court's apportionment decisions, 1 through 8 from last decade, is that a challenger alleging that the legislature had violated a state constitutional standard must show that the legislature could have complied with that standard and those of a superior priority. If the challenger showed that, the court declared the district invalid. If it did not, it upheld the district. And our brief at pages 31 to 35 shows that this approach was applied again and again in the initial validity review of state legislative districts and ultimately in litigation over the state congressional districts.
The record here, I think, would be much more straightforward for this argument in our consideration of it if there had been a trial. And I mean, without getting into the tactics of why that wasn't the case, I mean, do you concede? Am I right about that? I mean, if we had a fully developed trial record, we would be in a better position than we are today to judge their alleged failure to meet this burden.
I don't think that's necessarily true because in the validity decisions on the state legislative maps, there's no trial record. This court has briefing on stipulated facts and presentations, written presentations, and this court is in the same position as the trial court to evaluate the evidence in front of it. So that's why, as we've indicated on our standard of review, the standard of review here is not the clear error standard that the plaintiffs propose, but it's a de novo standard. So this court's in the same position here that it is in the validity cases. It has statistical evidence, it has maps in front of it, it has a legislative record, and it's in a position to make that determination here. And this is the right approach. More importantly, it's consistent with precedent, but it's also an approach that makes sense. The presumption of validity and the concept of redressability require a plaintiff to prove the validity of and the availability, rather, of a permissible remedy.
Counsel, do you think that that in any way kind of conflicts with what the Supreme Court has said about the burden in racial gerrymandering cases? That sort of burden shifting, if they're able to show diminishment are an issue, is that, you know, kind of violating what the Supreme Court says about the shifting of the burden?
I don't think so in this context, because what we're talking about here is the potential availability of a remedial district. The trial court appeared to have treated this equal protection claim as though the legislature and the Secretary of State were raising affirmatively a racial gerrymandering claim against a hypothetical district, and it said we have no standing to do so and that we hadn't proven our burden to do so. That's not the argument that we're making. The argument we're making is the one that the Chief Justice mentioned earlier, that it's impossible to comply with both. As Justice Curiel said, if there is a conflict, if it's not possible to comply with both the state constitution and the Equal Protection Clause, the Supremacy Clause clearly dictates which of the two prevails. It's the Equal Protection Clause.
Can we talk about predominance? And I'm curious what the world looks like if you prevail in this case, going forward, I mean, it seems like before, including this, in this cycle, the legislature approached the FDA just in a kind of straightforward way of, you know, without thinking that trying to just follow the, if we just draw a circle around the Florida Constitution, the FDA, that without thinking that this federal equal protection stuff was going to sort of intrude on that. So, you know, you do your performance stuff, everybody's talking as if we need to preserve the minority districts, that's the priority, then we, you know, work around that. It seems like now there's potentially a paradigm shift where you maybe can't just kind of follow the roadmap that the FDA itself lays out. So what is the legislature supposed to do going forward? I mean, are they supposed to kind of ignore the priority part of the FDA and just sort of put race on the same footing as all the tier 2 things? Or, you know, what does redistricting, you know, 2030 look like if you win?
Sure. So I agree it's an important question, and in almost every case, it is a straightforward exercise. The legislature is able to draw districts that comply with Tier 1 and Tier 2 without race predominating. And of course, Tier 2, the introduction to Tier 2 of the Florida Constitution says unless there is a conflict with Tier 1, the Tier 2 standards prevail. So if there's not a conflict, if the legislature is able to comply with the non-diminishment provision while also complying with compactness and boundary usage, there simply is no conflict or a need to prioritize between the two.
But do you, from a predominance perspective, though, do you have to sort of draw the Tier 2 compliant maps and then sort of back check to see what happened, or do you know what I'm saying? Because it seems like it seems like there's a potential disagreement here. If I start with the necessity of non-diminishment, then I've put myself into sort of strict scrutiny land. If I'm starting with the other stuff, maybe I'm not. So how do you think through that?
So let me give you two examples from the congressional map where the legislature is able to comply with Tier 2 and also comply with the non-diminishment provision. You could look at Congressional District 24, which is in northeastern Miami-Dade County, east of Hialeah, north of the MacArthur Parkway. It's a 42% black voting age population district that doesn't diminish as compared to the predecessor district, but it's also a district that has among the highest compactness scores in the entire congressional map. There simply is no conflict between Tier 1 and Tier 2, and there's not any indication or need for race to predominate. That might be an example where the legislature in the U.S. Supreme Court's parlance is race conscious, but race does not predominate in a way that raises equal protection concerns. The district immediately to the south of that, District 27, which is Coral Gables and the surrounding areas, if you look at a map, it's a circle. It's about as close to a circle as you can get in a congressional map that requires exact equality of population. It has an extraordinarily high compactness score. It's also a district that's 74% roughly Hispanic voting age population and doesn't diminish with respect to the benchmark district that preceded it. So those are examples, and there are others that we've cited in our brief, where the legislature doesn't face that conflict between the race-neutral imperatives of the Equal Protection Clause and the instances where the Florida Constitution or the Voting Rights Act might require some level of race consciousness. And I agree, that's a tension through this case law. The U.S. Supreme Court said in Abbott and in Vera that the Equal Protection Clause and the Voting Rights Act sometimes pull in opposite directions. Sometimes that conflict is reconcilable without violating either. The difference here, and the difference that was recognized early in this legislative process, is that what was possible in South Florida simply isn't possible in North Florida.
So in the next cycle, if there's a situation where someone puts forward one map that meets all of the Tier 2 stuff, and someone else puts forward a map that meets Tier 2 and preserves a minority district, are you allowed to, because of the command in the Constitution, are you allowed to choose the minority one without creating strict scrutiny issues, or how does that work?
So I would say that the legislature's obligation in the first instance is to attempt to comply with all provisions of the Constitution. If it can do that, if it can draw a district that complies with the Florida Constitution and the Equal Protection Clause, then there simply isn't an issue presented here.
By choosing it for the racial reason, you're not creating an equal protection problem.
I think if there were an example of a specific choice between two districts explicitly on the basis of race, that might raise some questions under the United States Supreme Court's equal equal protection precedent. I don't think that's necessarily the case in the process of organic map development here, because often, as in those South Florida districts that I mentioned, those districts simply make sense for non-racial reasons. You have districts in different portions of a county that are compact. North Florida, though, as we've known for the last 30 years, the mathematical and demographic reality is that the black population of Jacksonville, of Duval County, does not have the ability to elect in a congressional district without being joined with a population either to the south in Orlando or far to the west in Gaston County and Leon County.
You mean just from a numerosity standpoint?
That's right. And the legislature, as you saw in the initial maps that were vetoed, was doing excellent work to try to square that circle, to try to comply with the non-diminishment provision while avoiding racial predominance. And the legislature's map drawers, I would say, are second to none. Jay Farron and his team on the Senate side, his counterparts in the House and the governor's people, they're extraordinary map drawers.
Well, as Justice Kennedy noted in a dissent many years ago, they are insulated from the political process, and that's sort of the idea, right, is that they don't have an incentive one way or another to do anything other than get the math right.
That's exactly right. And so the plan in 8015, the East-West district, it's certainly better than the benchmark district on some statistical metrics. My friend on the other side mentioned boundary usage, that it's, well, of course, it's squeezed between the Georgia border and Interstate 10, so it follows geographical and political boundaries in those areas. But if one were setting out, if the legislature were setting out to draw a congressional district and their primary goal was boundary usage, they wouldn't draw this horizontal seahorse from Chattahoochee to Jacksonville. There's no way that they'd do that. And there's not been any explanation by the plaintiffs for this appendage into Leon County. How is that appendage into Leon County justifiable on any ground other than race? This court and the first district, where this case was argued last October, are both in congressional District 2. But if you were to take a straight line between the two districts, just 2 miles, you'd enter and exit District 5 twice. This is a district that divides Leon County and Tallahassee on the basis of race. It divides Florida A&M University from Florida State University. There's no non-racial grounds for a configuration like this, as opposed to Congressional District 2 in the enacted map.
Is the argument, is this, it seems to me that the difference between the Secretary and legislature's argument is different approaches to the same problem, which is that if we go with the benchmark plan being the existing plan, it's kind of inescapable that there's at least a racially suspect district in that plan. So do you see the difference in the arguments more as one to how to address the same issue, or is it truly two very separate arguments?
I think there may be complementary approaches that address the same issue. I think and not to speak for Mr. Whitaker, but I think their argument on the benchmark district is that this court can look at it and determine that district is not a valid benchmark district, that district was drawn for racial reasons and doesn't deserve the respect of this court in evaluating the benchmark. Our argument is a little different. Our argument says even if you presume that district is valid, do what the legislature did with respect to every other benchmark district. It's simply not possible to show that a alternative remedial district could be drawn that both doesn't diminish and in which race doesn't predominate. The plaintiffs have had every incentive in the world for the last 2.5 years to try to show how it could be done. If it were possible to draw a circle, a square, or maybe even a long rectangle that wasn't race predominant, that didn't diminish, surely they would have done so. Or the federal plaintiffs in the 3-judge court here in the Northern District would have done so. They haven't. No one's been able to improve on the work product of 8015 and 8019 in the legislature, and we've shown on the record here and explained in our briefs why both of those are problematic.
So
8015.
I'm sorry. So we're obviously going to potentially make law on the racial side of this, but that we make law on on what's a compact district. What are we? One way of addressing this is to just say it just race was the reason for drawing the district, and so we don't need to get into the circumstantial evidence of whether it's compact or not. But if we do say that part of the problem is that it's that you're not following tier 2 and whatever, then we would have to sort of say what our reason is for saying that it's not compact. And so how do we decide that? Because normally the legislature would be asking the court to give it a lot of leeway as far as defining compactness. And so what are we comparing that district to the alternative district, the east-west, what are we comparing that to say that it objectively, as a matter of law, is not compact?
Well, I mean, there may be hard cases. I don't think this is one. This is the least compact configuration in either the enacted map or the benchmark map. This east-west configuration, and to your point earlier, Mr. Chief Justice, the only reason, the only justification, rather, under the Florida Constitution for deviating from compactness under Tier 2 would be a race-based reason. There's no other justification. The state can't. Tier 2 requirements are mandatory in all instances unless Tier 1 requires
But they're
something.
saying it doesn't deviate from compactness. And so I'm just trying to understand how are we, if we just sort of isolate that issue, because I mean, there's always going to be a least compact district, right? I mean, so, is it by a certain amount, or how are we, because we're going to make precedent on that too, it seems. So what are we looking at?
So I think what this court can do is look to the same sorts of things it looked to in apportionment 1 and 2, the presence of odd appendages and bizarre shapes, in addition to the mathematical measures of compactness. So looking at the mathematical measures of compactness, which I agree there will always be a least compact district, this is a district whose non-compact configuration isn't dictated by geography. The districts, the Senate districts and the congressional districts that include the Florida Keys are usually low on the compactness measure. That's because of the geography of the state. That's not the case here. It's possible to draw squares and rectangles in North Florida. So there's no geographical explanation for the low mathematical compactness scores. And the visual compactness here, if you look particularly in Duval County and even more particularly in Leon County, there are appendages which suggest something going on here that is problematic from a compactness standpoint. So those drive the sort of numerical compactness scores. This court says that you apply the interocular test. It hits you right between the eyes to see whether it's a compact district. That's the sort of thing you could look at in this case.
And I noticed, so in your brief on the Duval district, you raised the issue of the fact that it doesn't perform as well as the benchmark, but you didn't make the argument that I think they do, but I didn't think that you made the argument about the surrounding district being a problem, because it seems, I mean, if the only problem were that it didn't perform as well as the benchmark, it would be a weird rule for us to say, well, if you can't keep it at exactly the same level of performance and you have an option that performs maybe not as well but still well, that then the legislature can just sort of go from the benchmark to nothing that even comes close to performing. Like, that doesn't seem like that would be reasonable.
Well, you're right. That's not an argument we make. It's an argument the Secretary makes, that race would predominate in Plan 8019. But I don't think it's an odd result in this case, because the Florida Constitution prohibits diminishment. So if the remedial district would itself diminish, that can't be a valid alternative district. The plaintiff's burden is to show that there's a remedial district that complies with the state and federal constitution, not one that accomplishes some other objective that they might have, but in a way that doesn't.
But I mean, do you advise, I mean, when you're telling the legislature what to do you tell them that if you can't maintain it at exactly the same level of performance, then all bets are off? I mean, if, you know what I'm saying? Because there was this district, I mean, obviously the legislature passed it as their primary map for a reason. It doesn't perform in 14 out of 14. It's what, 9 out of 14 or something? I mean, it would be a strange thing for us to interpret the diminishment provision to tell the legislature that it's all or nothing.
I don't think so. In apportionment 1 and 2, this court said diminishment, the plain definition of diminishment is whether the new district is more equally or less likely to perform for the candidate of choice. In this case, you said it's less likely. The Duval-only district in Plan 8019 is a white majority district that would have elected Rick Scott, Marco Rubio, and the Republican cabinet officials in 5 of the 14 statewide elections between 2012 and 2020. It's a district that, other than outside of this case, the plaintiffs would of course be saying is diminishment. From 14 out of 14 to 9 out of 14, this court would say is a diminishment.
So do you think that the district that curves around it, is that a compact district?
It would be less compact than the enacted map, to be sure. We've not taken the position that it is that race predominates and that it would be a racial gerrymander. Our position, the legislature's position, is based on the non-diminishment clause on Plan 8019. And the plaintiffs say that the legislature has has said that that district would perform and that district would comply with the non-diminishment provision. The actual context of Chair Leake's comments, he says that it's a singular exception to the non-diminishment requirement. In other words, it's a district that doesn't comply with the non-diminishment provision, but is one that the legislature was putting forward in an attempt to address the equal protection concerns that the governor had raised through the legislative process and in the advisory opinion request to this court. Unless there are further questions.
I have a final question for you. What are we to make about the first district's position that we don't make binding precedent when we're sitting in our original jurisdiction?
That's not an argument that the legislature put forward, and particularly in the case of the validity review of state legislative maps, the Constitution provides that the result of that proceeding is a declaratory judgment binding upon all citizens of the state. The legislature has presumed that this court's decisions are provide binding precedent for it to follow, and we did not make that argument.
Thank you.
Thank you. This court should affirm and remand for entry of judgment in favor of the respondents.
Thank you.
Just a few points in response. So, Mr. Chief Justice, you have expressed a number of times today you're sort of concerned that the FDA on its face requires making non-diminishment a priority. And I want to point out that that is very different than requiring lawmakers to prioritize race at all costs. And in a lot of ways, the FDA and the VRA are very similar, right? So the state has an obligation to also prioritize the VRA as well. That ends up being a little bit of a moot point in Florida, given the FDA's. But the Supreme Court has always said that compliance with the VRA, intending to comply with it, is not racial predominance. And if anything, I think the FDA's are better than the VRA, because the FDA's expressly include that Tier 2 restriction on the legislature as well. It affirmatively requires it to take compactness into consideration when drawing. So if anything, I think the FDA's are on firmer ground here. Your Honor's asked also some good questions about compactness. How do we measure compactness? Of course, in Apportionment 1, this court said that there's no mathematical measure. Something it also said is that the legislature has to make trade-offs between compactness and adhering to political and geographic boundaries. Not all counties are drawn particularly beautifully. The Gadsden County line and the Nassau-Duval County line are good examples of that. City lines don't necessarily follow something particularly beautifully. But in Tier 2 itself, it says there's no priority among these. So there's no priority between compactness and adhering to geographic and political boundaries. And the
Actually, I thought it said it's if to the extent feasible. I thought compactness is sort of a, okay, I'm sorry, go ahead.
This court certainly held in Apportionment 1 that the legislature is completely entitled to make trade-offs on which one it would want to prioritize. And those are real trade-offs. So let me give you an example. If you look at the enacted plan, two of the most compact districts are CD10 and CD15. It's sort of the Tampa Bay and Orlando areas. They're almost little bubbles. They performed the very worst on adherence to political and geographic boundaries, where the version in Plan 8015 has only 2% of its boundaries that don't follow an existing boundary. Those are in the 30s. I think it's like 32 and 34%. So there is a real trade-off to be made here, and the legislature chose, for whatever reason, it was their prerogative, to put more of an emphasis on boundaries with CD5 than with compactness. And I don't think that...
But don't we presume that the reason they did that, I feel like I'm sort of returning to the first principles that I started with, is that the bottom line, the goal here is one person, one vote. That's the legislature's first goal. The Voting Rights Act and the Fair District Amendment are like further elaborations on that principle. One person, one vote without regard to race. I feel like when we become sort of detached from those first principles, we wind up sort of tying ourselves in knots about all of these meta-analyses when, that sort of core anchoring principle explains so much about why, for example, you might have a district that scores low on some compactness score. Well, it's because the legislature was trying as best they could to carve up the state so that every person would count the same. Am I wrong about that? I mean, doesn't that sort of answer your point about how some of these districts may be very uncompact, but if you take a step back, what winds up happening is that a voter in Duval who might be sitting in a weirdly shaped district winds up having the same vote as someone in Miami-Dade in a perfectly compact district. Am I missing something?
Your Honor, I take a little bit of issue with one of the premises of your question of that it's a problem or that the maps need to be drawn without regard to race. I think Supreme Court precedent says the exact opposite, that in fact to comply with your obligation under the VRA and here under the FDA's, you have to take race into account.
That's different. I think Shaw versus Reno, I think Justice O'Connor perhaps stated better than anyone else the fact that, and I think the Chief Justice has said it as well, taking race into account and being mindful of race and of the history of prejudice is very different from using race as a guiding, predominant, to use your word, principle. I think if CD5 had been drawn in the configuration in which it is drawn to maximize white performance, it would look like a district precisely of the kind that motivated the Voting Rights Act. It would be a racial gerrymander, as I think what we would be hearing from you, and indeed it's what we've been hearing very rightly for generations. So I am concerned that this line between what is a predominant consideration and what is a valid consideration gets blurred when we lose sight of first principles.
Your Honor, I'm glad that you mentioned Shaw, and I think this court is looking for some guiding principles, or not to use the word benchmark, but some benchmarks here to give it some guidance. And so I encourage the court to look at the U.S. Supreme Court's seminal cases on racial gerrymandering. So Shaw, Miller, Bush v. Vera, and to look at those districts. We put them in our reply brief, actual visual pictures of them. I think it's at pages 25 to 28. They show what a racial gerrymander on the basis of shape looks like. And those were districts that scored 0.01 on the Polsby-Popper score. Here are the version of CD5 in Plan 8015 is 11 times better than that.
But you have to admit, I mean, they talk about, especially in Miller, I mean, there's the tension between the idea that, you know, you use the weirdness of the shape to infer that race was predominant, as opposed to here where we have an entire process and a constitutional text that tells you that you can't diminish and that that's a priority over the other stuff. So in some ways, here the shapes and everything, it arguably just doesn't even matter. If you're just trying to ensure, if you're sort of starting off where that's kind of the master rule that sort of, has, runs through the way the whole process works.
I agree. So Shaw was singular. I agree. Shaw was really just saying this cannot be explained on the basis of its shape. We think it's a racial gerrymander. But in most of the court's other cases, the state is attempting to comply with the VRA, similar to like we have here. But it's the shape that takes it over the top here. Yeah. And I think that.
And I guess, do you think though that, it seems like the court is assumed that complying with the VRA is compelling interest. They talk about the origins of the VRA and the authority that Congress has. I don't know that we can sort of translate all the things that the court does to try to make that okay. The VRA okay and the sort of prophylactic measures. I don't know that we can assume that a state government has the same sort of leeway to adopt, facially kind of race-conscious mandates and have courts sort of struggling to find all these ways to make it constitutional.
Your Honor, for all the reasons I've said, I don't think the court needs to reach the strict scrutiny argument today. But I disagree that states don't have the power to take action to protect minority voters absent some sort of requirement from Congress. And the Supreme Court has time and time again emphasized that states get leeway to go above and beyond what's required by federal law.
The above and beyond requirement doesn't work when the pie's only so big though, right? I think it keeps coming back to whether it's individual or group. Because if you're going to take the position that we can set a higher ceiling for minority groups, and it seems we're lowering the floor beyond the 14th Amendment for what you would consider a majority race.
Your Honor, maybe I shouldn't have said above and beyond, but the point I'm trying to make is the state can take actions that federal law doesn't require it to do, right? So let me give you an example. In the case Voinovich v. Quilter out of Ohio, this is a case from the Supreme Court in '93, the state of Ohio intentionally drew majority-minority districts that were not required by Section 2 of the VRA. And the district court threw that out because it thought the state just didn't have the power to do that. And the Supreme Court reversed. It said, the federal Section 2 is a restriction and a requirement of what states must do. But states have the power to go beyond what federal law requires of them to do, right, with the backstop, like if it is not otherwise violating racial gerrymandering principles. And we do not think that Plan 8015 or 8019 violate those principles. So even in the absence of some federal requirement that Florida do this, Florida had the power to do this. Your Honor, I would like to go back very briefly to Plan 8015 and just to emphasize that it is in the record that the state can comply with these two things, both non-diminishment and the Equal Protection Clause, to the extent the court has concerns about Plan 8015.
That's the Duval-only plan?
Yes, the Duval-only plan. So in the record, the House redistricting chair said this district faithfully adheres to all Tier 2 principles. That's at the record at 9056. And Mr. Norby today affirmed that they think that district adheres to Tier 2. And the legislature also said that although there's a decrease in the black voting age percentage, our functional analysis concludes this is a reliable performing district, end quote, for the black candidate of choice. And so I completely agree with Mr. Chief Justice that there's a difference between, if the legislature is fully able to protect at the same level, of course they should do that under the diminishment standard. But if this court concludes that it's not possible to reconcile these, we think it is, but if the court concludes you don't think it was possible, I don't think the answer should be that we throw out the district entirely. And maybe those are questions we reserve for another day, and maybe the court remands back to the trial court to consider this.
I'm curious about, and I'm not saying this isn't like a telegraphing anything or whatever, but it seems like in this litigation there's been the government has been sort of trying to walk a fine line between facial and as applied. And some of the arguments just seems like it's inevitably heading down the path to we're going to have to just sort of decide can FDA work when it sort of on its face requires non-diminishment, getting to what Justice Sasso said, and it's sort of prioritizing one set of racial groups over another, whatever. If it ever were to come to the point that we thought that the non-diminishment essentially doesn't work here, would the whole FDA have to go? Because it seems like this was part of a kind of package deal. The way this was sold was that you could have the apolitical, you could have the compactness and all that, and that it wasn't going to hurt minority voters. If we sort of take out or neuter half of the bargain, do the voters get a chance to just sort of start from scratch, or are they stuck with the half that was sort of lived with in exchange for a sense that that it wouldn't hurt minority voters to do this? Because I know that at the time that this was adopted, that was one of the main things that people were struggling with, is what happens to these districts that aren't necessarily, the Corinne Brown district was never 50%, so it wasn't going to be required by Section 2. Section 5 didn't apply up there. This was supposed to be kind of the remedy for that. So how do we neuter half of this thing and then leave the other part intact?
Your Honor, I do just want to clarify, although the Secretary, preserved an affirmative defense of the Fair District Amendment's facial unconstitutionality in the stipulation, my understanding is that they have abandoned it. They have not argued that the Fair District Amendments are facially unconstitutional. Certainly the legislature has never argued that and thinks that it can apply it constitutionally. And I think, to the extent that the court has concern about one district in the map, certainly does not suggest that the whole thing would need to be thrown out. The racial gerrymandering backstop would be the appropriate course for the court to take if it fundamentally had a concern, an unresolvable concern about CD5. But no, to answer your question, I absolutely do not think the answer would be to throw out it entirely. I think it would be to see what limits we could put on the provisions. Perhaps the court would take a different interpretation to sort of avoid the constitutional question would be the right answer. Just to conclude, Your Honor, petitioners are not asking for anything extraordinary here. We are asking for this court to adhere to its existing precedent, to continue to apply the law as this court set out in 8 apportionment cases. And we ask the court to reject the state's invitation to upset the settled law and to really stretch racial gerrymandering doctrine beyond its recognized limits.
Okay.
Thank you.
Thank you. We appreciate the excellent briefing and argument, and we're going to take a 10-minute recess.
All rise. All rise. The Supreme Court of Florida is now in session. Please be seated.
Our second and final case for today is Jones versus State of Florida.
May I please support? Counsel, Robert Pierce on behalf of Mr. Jones.
Could you speak up a little bit or maybe move the mic up? That's okay.
Robert Pierce on behalf of Michael Jones. We requested 5 minutes of rebuttal time.
I still can't hear you. I'm sorry, counsel.
Robert Pierce on behalf of Michael Jones. We've requested 5 minutes of rebuttal time. Excuse me. Well, good morning, and thank you all for the opportunity to discuss this case. This capital case stems from Mr. Jones's plea and conviction for 4 killings occurring in Marion County, Florida in 2019.
Counsel, I'm so sorry. I'm still struggling to hear you a little bit. I don't know if it's a microphone
Hey,
or just
Woody,
the volume.
can you turn it up?
I can try to just use the
You're just
auditorium
use your
voice.
booming voice.
Yes.
Sure.
Free tone.
Okay.
You kind of got an empty courtroom behind you, so you got to
This,
speak up.
I'll try not to take it personally. This capital case stems from the killings of 4 killings in July and August of 2019 in Marion County, Florida, and from the ultimate recommendation of death following a penalty phase in 2022. Now, for the purposes of our discussion today, I believe
Well, it actually stems from 5 killings. 'Cause
Yes, Your Honor,
what
that's
got
correct.
it off was
This-
the one killing that's not, for which there's no death sentence.
Yes, correct,
Which is
Your
not
Honor.
really before us, but that is what started it all off. I mean, that's the,
Yes,
isn't
Your
that
Honor.
correct?
I agree. Yes, I didn't mean to represent otherwise. But the 4 death counts before this court, the 4 things that we're seeking a remedy for are those 4 first-degree murder charges for which he was ultimately sentenced to death in 2022. Now, for the purposes of our discussion today, I believe we're just going to be focusing on point 1, which deals with the denial of a special jury instruction regarding the avoid arrest aggravator, for which we're seeking the admittedly significant remedy of a new penalty phase. The avoid arrest aggravator originally applied to law enforcement officers, but was expanded to cover other individuals by this court's decision in Riley in 1978. And for 50 years, that we've had essentially an additional element where the victim is not a law enforcement officer that requires the state to prove beyond a reasonable doubt that the sole or dominant motive for the killing was the elimination of a witness to avoid arrest.
But counsel, is it your argument that you proposed sort of this alternative theory, right, that he had a psychotic break? If the jury, based on the instruction as given, if the jury had not found that he was avoiding arrest beyond all reasonable doubt, meaning they would have decided it was a psychotic break, if they had believed your theory of defense, that the standard instruction would have covered that.
Respectfully, I disagree, Your Honor. And I think the problem with the instruction is because and the state has made this argument in their answer brief, that the language, the text of the aggravator, which is all the jury was given, was essentially the same as this additional element of a sole or dominant motive. And I think those two things aren't, I would disagree. I think requiring the state to prove beyond a reasonable doubt that the sole or dominant motive was to avoid arrest via the elimination of a witness is a higher standard than is implied by just the plain language of for the purpose of avoiding arrest.
But why is that? I mean, I understand it makes the point more forcefully. I don't question that. But the standard instruction says that the first-degree murder was committed for the purpose of avoiding arrest. Now, I don't see how that is materially different than what you were asking for. I understand what you're asking for is more emphatic, but if you actually look at it, what it says, the purpose is the purpose. It's not a purpose. It's not some one of many purposes. It is the purpose. That's what the standard jury instruction says, and I think that follows the statute. And so I struggle with why this is material.
Well, I think it's informed largely by the 50 years of precedent from this court requiring that extra element to be there, to be proven beyond a reasonable doubt, and using that specific language of sole or dominant motive. And if it wasn't a big deal, then I don't think we would have the legion of cases that we do have requiring this proof to be made. I want to point out also one error, I think, and this was the point that was made in the brief. Just briefly, I believe I addressed this as the state contesting point, or the second Stevens factor. It was, in fact, the third, so I apologize for that error in the reply brief. Assuming, for the sake of argument, that it was an error, the question then becomes whether or not that error was harmless. And I think there's two paths to get there. The first, or rather, there's two arguments that we would make to prove that the error cannot be deemed harmless beyond a reasonable doubt. The first is relying on the Supreme Court's decision in Espinoza, among others, which held that in order for that a sentencing aggravator is invalid if it leaves the sentencer without sufficient guidance to determine the presence or absence of that factor. So, just as you were mentioning, if you were to agree that the sole or dominant motive is an additional element that is material to the jury's determination of the presence or absence of that factor, it's the defense's position that that would mean that that factor is invalid, and that or in other words, the absence of the element before the jury to determine the presence of this aggravator renders it invalid, and because of that, we then go to Brown v. Sanders, where, as Justice Scalia explained, where the jury or where a sentencer, here the jury, is presented with an invalid aggravating factor, the question is then a pretty simple one. It's simply whether the sentencer could have considered the facts and circumstances underlying that aggravating factor, the invalid aggravating factor.
But wasn't Brown was about sort of just the aggravators. That wasn't a harmless error standard case, correct?
No, Your Honor. I believe it was just, well, the ultimate question in Brown was whether or not the sentencer's consideration of an invalid aggravating factor rendered the sentence unconstitutional, requiring a remedy. And while it held in that case that it did not, the rationale, as Justice Scalia explained, was just looking at whether or not the jury, or the sentencer rather, could have given aggravating weight to the same facts and circumstances under any of the remaining valid aggravating factors.
Right, but that's not really what we look at, right? I mean, our harmless error standard, when we are, let's say we agreed with you and said it was an abuse of discretion for the judge to not have given that jury instruction, and let's say we find that that was error. Now we're going to look and see were there, would the jury have still been able to reach the same decision, correct? I mean, does that error contribute at such a point that we're concerned about the validity of the penalty phase, correct?
No, Your Honor, I'd have to disagree.
So?
The test for harmless error is not whether the jury could have reached the same result. The test is whether or not there's a reasonable possibility that the error contributed to the outcome.
Fair.
Here, I think, and again, I have a separate argument for the more traditional harmless error analysis, but I think for the purposes of this, what we learned from Brown is that we don't get into that, we don't need to get into the weeds of whether or not there's a reasonable possibility that it affected the outcome. It is per se unconstitutional if the sentencer reached their decision by considering an invalid aggravating factor where the jury could, or where the sentencer could not have otherwise given aggravating weight to the underlying facts and circumstances.
Have we ever applied that this way in any case?
No, Your Honor. Brown has not been cited by this court in this court's prior jurisprudence, but I don't believe that that is dispositive of whether or not it is actually applicable. Secondly, just to turn to, well, actually, one more point before moving on. There's a second problem with applying, or there's a second reason why the aggravator, as applied in this case, should be considered invalid, and that's because in Zant, the factors that will render an aggravating factor invalid aren't limited to just failing to sufficiently narrow the sentencer's guidance on determining the presence or absence of the factor. They also include circumstances where the conduct underlying the aggravator may actually or ought to actually militate against the death penalty. And here, because it is so unreasonable to conclude that, as the state is suggesting that the defendant did, that these actions would have in any way prevented his arrest. I mean, there were no witnesses to these crimes. There's no connection from these individuals to...
Because your client saw to that.
I'm sorry?
Because your client saw to it that there were no witnesses. I mean, I guess that's the point, is that, you know, as I see the record, there's a sequential pattern to the killings.
Yes.
It has to do with raising of questions about prior killings.
Yes.
And the noted absence first of Casey and then of the others. It seems to me that it's very difficult to conclude that there isn't a driving motive here, including the destruction of any potential witness testimony.
Well, first, I don't believe, and I'm fairly certain the record backs me up here, none of the individuals involved in this witnessed any other, not only did they not witness any other murder, they didn't witness any other criminal act by the defendant at all. And so we don't have a situation here where we're dealing with the elimination of any witness. And as this court held in Consalvo v. State, I believe in the 90s.
I just feel like that's a real narrow view of witness. I mean, particularly when he's lying about, you know, where she is and that sort of thing, and then you have kids who could corroborate, you know, the information that he's saying is wrong. I guess your view of witness is somebody who actually saw the murder committed versus somebody who, a witness that could lead to his arrest and
Yes,
conviction.
exactly, Your Honor. And that's not just me saying it, it's also this court in Consalvo v. State where this court said that the mere fact that the victim knew and could identify the defendant without more is insufficient to prove the aggravator.
Well,
And
yeah, but they could do a lot more than
Yeah.
know and identify the defendant in this case. When was the last
Correct.
time? When was the last time you saw your mother? When was the last time, you know, did you hear them fighting?
Right. And I think the distinction is simply between facts that could give rise to suspicion that would lead law enforcement eventually to his doorstep and what we have in the application of this aggravator traditionally. I'm unaware of any other case where it has been applied that loosely to individuals who did not witness the offense at all.
Well, but you know, you're stepping back from all that. It just seems like overwhelmingly obvious here that he decided to kill these children, you know, sequentially, in order to avoid having his story about his wife, who he had murdered, fall apart. It was all about keeping this fiction about the wife, which was designed to cover up his murder of her. It was all designed to cover that up.
I think there's the problem with applying an I think the problem is with applying an aggravating weight to the sequence of events that we see here. I mean, that is...
Well, you want to talk about aggravation. I cannot imagine a more aggravated case than this case.
I totally agree.
Murdering 4 innocent children, 2 his own flesh and blood, and the others his stepchildren. The aggravation just cries out.
Yes, Your Honor. And let me be perfectly clear. There is no doubt that the aggravation in this case is significant, it's severe, it's weighty. I cannot imagine a reasonable person arguing otherwise. That is certainly not my position here today. The question, even under a traditional harmless error analysis, is simply whether there's a reasonable possibility that the error contributed to the outcome. And the reason why I believe this issue exists is not because I think the aggravators are not weighty. They certainly are. There's no question they are. The reason why is because the mitigation is significant as well. And because these senseless acts can't
Counsel,
be...
I'm struggling how to see that the standard jury instruction is really any less favorable to you than the instruction you requested. If they buy what you're selling about this aggravator, either instruction, they're going to find it's not there. It seems to me. Because it seems like your theory of why the aggravator should not be found works under either instruction.
Well, respectfully, I disagree, Your Honor. I don't believe the state's case is sufficient to prove this aggravator. I don't think it should have gone to the jury at all. But if it was going to go to the jury, I don't think it should have gone to the jury without the element that this court has required the state to prove beyond a reasonable doubt for nearly half a century. And again, I want to make this point because I think it's important. Again, yes, these aggravating factors are significant. There's no doubt about that. But these acts can only be understood. They only make sense in the context of the significant mitigation that was presented in this case, that he was vulnerable to psychosis, that he suffered, the expert testimony that he suffered a psychotic break, that was the cause of all of this, and his continued, the continued deterioration of his mental condition once he was in custody. It's the only thing that's made it make sense for me, and it's why I'm standing here right now, because
Counsel,
I do believe.
Is that really what we have defined as significant mitigation? And we see a lot of these cases with very significant mitigation.
I understand.
Would you say that this court has defined a psychotic break as significant mitigation in the past? Because that's really your only mitigation, correct?
My point in mentioning these things is not to say that, of course, now reversal is required because of this defense mitigation.
I understand, but I'm kind of going to the reasonable possibility that this contributed. There were 5 other aggravators found by the jury and the trial court, which comprised much weightier issues than the avoid arrest aggravator, correct?
Correct.
And so it is difficult, I think, for you, even if you can convince Justice Kennedy on the jury instruction, to get past the harmless error standard.
I understand. And just to be clear, the reason that I mentioned the mitigation is not to say, or to convince any of you that you would have voted for life in this case. My point is only that the mitigation was significant enough that this wasn't an automatic decision for the jury, that the jury could have been, that this thumb on the scale could have been the thing that affected the outcome, that it could have, that there's at least a reasonable possibility that it contributed to the outcome. I understand the reluctance to approach it, given how weighty these aggravators are, but ultimately we're dealing with executing somebody, and in that very serious decision, a thumb on the scale shouldn't be tolerated.
Where do you see the line between reasonable probability and possibility when you're talking about a thumb on the scale?
I think largely informed by the logic of Brown v. Sanders, but it wouldn't need to apply. Just the fact that the jury is giving aggravating weight to anything outside of the aggravators that ought to properly be in front of it, or that are properly in front of it. The moment that it's able to give aggravating weight to some other aggravating factor that shouldn't, that's where I believe that reasonable possibility comes in a case where we have, significant aggravation, but also significant mitigation as well. So respectfully, I'd request this court remand for a new penalty phase.
Thank you.
Good morning. May it please the court. My name is Doris Meacham, and I'm here on behalf of the state. During opening arguments, defense counsel made it very clear that there was really only one aggravator that was at issue in this case. In fact, they conceded to all the other aggravators that they were proven by the state. Their argument was motive. They made that very clear in the beginning, that the state was going to argue that the defendant killed the children because he was trying to avoid arrest. And the defense's position was the motive and reason was because he had a psychotic break. The standard jury instructions were sufficient enough for the jury to decipher what it meant. If you look in the dictionary under motive, it means reason, goal, objective. Purpose, reason, goal, objective. They both mean the same thing. during the motion hearings, the state argued the same thing as I'm arguing today. The language in the standard jury instructions was pretty much the same thing that defense counsel was asking for. As for the reasonable doubt instruction added, or the language added in the instruction, as the prosecutor stated, it was redundant. And I believe it would have been misleading to put that reasonable doubt just in that aggravator when the jury is instructed that each aggravator has to be proven by the state beyond a reasonable doubt. So there's no reason to put it specifically into that aggravator itself. To meet his burden for the proposed instruction, he would have had to meet 3 different prongs. And because defense argues that it was a correct instruction that it should have been given, well, that's not the way it works. The reason that the judge did not give the instruction was because it was legally adequate. And what they were asking for was the legal threshold to get the aggravator to the jury. And it was not necessary to put that language into the jury instruction, and I don't believe it was. If you want to look at the harmless error in this case, defense counsel argues that they considered what was used for the avoid arrest aggravator possibly to come to the conclusion that the other aggravators were proven as well. If you look at the closing arguments, if you look at the testimony and the evidence, everything that was used to prove HAC and CCP are the same things that were used to prove the avoid arrest aggravator. So there's no harm in this case at all. Whether or not the instruction was given, this jury still would have understood what the purpose of the defendant's actions were, which was to get rid of the kids. Even if you were to strike the aggravator, as the defense counsel said, the state proved each and every one of the other aggravators.
I think I agree with that. I am left with the question why the state sought this aggravator, given everything you just said. What does it add to the mix?
It's really, it's what triggered the whole thing. I mean, it's so intertwined with what happened in this case. For everyone to understand, as he said, the only thing he can understand is that he had a psychotic break. That's what makes him accept what happened in this case. That's not what happened in this case. That's what makes it so tragic, is that after killing his wife, he stuffed her into a suitcase, got up the next morning and reconnected with his ex-wife to rekindle their relationship, and came up with this story that Casey had left him and that he wanted to get back with his ex-wife. It starts right there. The moment he comes up with this fantasy of she left me and we're gonna move on with the new life. And once that starts to fall apart and he can't keep up that ruse, like when the school starts, that's exactly what the cop asked him. I need to know why you did this. And the thing he said was, well, school was starting. School was starting, I have to get rid of the kids. His exact words, I decided to choke them out. So he killed the first one that night. The next morning, his brother's asking, where's my brother? And he tells the cop, well, I had to get rid of him the next night. Every move he made when he killed those children was to avoid getting arrested. It wasn't because he had a psychotic break. It wasn't because he was mad at the kids. It wasn't because there was a struggle. The only purpose was to make sure no one found out that Casey was dead. And once the kids were going to start school, they were going to ask questions. And then the girls, they asked the defendant, why did you kill the girls? Well, I got an eviction notice. What am I going to do now? I've got these dead bodies in the house, basically. So he kills the girls. And he even tells the police officers, I drove to the police station that day to turn myself in, and I couldn't do it. Why? Because he didn't want to get caught. And so he had to go back to the house, and he killed both those girls that night. The last remaining witnesses, though they didn't see it, they certainly could get him arrested. So the state was wise in seeking that aggravator. Whether or not you throw that aggravator out, the jury was still going to come back with a death sentence. But I believe it was very important for the jury to know the horror of what the facts really were. And I don't believe that changing the standard jury instruction would have made any difference. They still would have come to the conclusion that he avoided arrest. That's why he did it. They didn't believe the psychotic break, which he never mentioned during the confessions at all. In fact, he said he hadn't been drinking, he was clear-minded, no problems. The voices in his head started after he was arrested. He never told them that he killed them because he was hearing voices. That came afterwards. And the jury did not buy that, obviously. There was no error in this case. The jury listened to the evidence. They heard all of the horror that happened to those kids. And they came to the accurate result, which was that he deserved the death penalty. And I would respectfully ask that you affirm the lower court's death sentence and conviction. Thank you.
Thank you.
Just a few brief points. Justice Scurio, you asked, what did this add to the mix? And we heard from the state that the jury needed to know the horror, and I don't think that's a sufficient reason. I think what this really...
I think, to be fair, the start of the answer was it went to motive.
Yes.
The aggravator is part and parcel of the state's case in trying to make sense of a senseless situation by explaining what the motive was for the sequential acts. So I don't think that's a fair characterization of what your friend was arguing. I think what I heard her say was it goes to motive.
Yes, Your Honor. I mean, it's... I heard them say both, but my point in mentioning it is that what it really introduces is that thumb on the scale, and it's the reason that I raised the issue in the first place. As a legal matter, my friend also mentioned that that this couldn't possibly be a harmful error, or couldn't possibly be a harmful error because the same facts were used to prove both CCP and EHAC. But the problem, as Justice Scalia pointed out in Brown v. Sanders, is that the analysis is not whether the jury was considering the same evidence, whether that evidence was properly before the jury. The question instead is simply whether the jury could have given aggravating weight to it. And here, CCP and EHAC do not share that same element of motive. The jury could not have been given, or the jury could not have given aggravating weight to motive under CCP, EHAC, or any of the other aggravators. Lastly, opposing counsel also mentioned the statements that he made during his police interview, but they didn't mention that he said he didn't know more often than that. And I mention that only because I don't think the extensive, exhaustive mitigation evidence establishing the serious mental illness that led to these acts can be just kind of dismissed as illusory. I think this case did present, as weighty and awful as these aggravators were, a close call because of those that mitigation. And from there, I think the reasonable possibility of a different outcome, but for the error, exists. So I thank you for your time. Respectfully request this court remand for a new penalty phase.
Thank you. We're adjourned.
All rise.